bear with me while we hope that the tech all works. I have got the coveted after lunch slot where everybody wants to have a little nap and digest. So if you listen better with your eyes closed, that's fine. I won't take it personally. But hopefully we will all stay awake till the end and then be rewarded with Eddie, who's up next. So I'm a content designer, and to channel a little Troy McClure from The Simpsons, you might know me from such things as talking about trauma-informed content. That's been what I talk about a lot the last few years. Trauma is not always the happiest thing to talk about, so it was quite nice to get asked to talk about something else. This is the first time I'm talking about human rights, so you are my guinea pigs. Be kind, ask lots of questions. So, human rights. It sounds big, it sounds important, and maybe it sounds a bit removed from us as designers. We tend to hear about human rights when we're thinking about court cases, or lawyers, judges, legal precedents, or maybe we're thinking of them when we think of areas devastated by war or famine, or places where there are immediate and visible crises happening. But we probably don't think about them when we log into our computers on a Monday morning in our offices. We maybe don't think about them when we join a new project to transform a website. We might not think about them when we see a video that doesn't have captions. But these actions can have human rights implications. And our work as designers and creators is fundamentally tied to helping people access information and services that are essential to their lives, and by extension, their human rights. We've probably all been in projects, and Holly and Helen were talking about this morning, where accessibility has been an afterthought, and we probably know how that turns out. Maybe we fail an accessibility audit, and we've got to invest more time and more money into making content more accessible. Or maybe we end up excluding a large number of our users who have access needs. What if we could turn that on its head? What if accessibility wasn't an afterthought, but the very place where we started our design? And what if we had that great big idea of human rights to help us turn accessibility from an afterthought and an edge case into the most important part of our design? So that's the dream. That's what we're going to be talking about today. We're going to get stuck into human rights, learn a little bit about them, and see how they can be a really powerful and useful tool for all of our design work. So let's start with what exactly are human rights. Well, human rights are set out in the Universal Declaration of Human Rights, or the UDHR. I do use a few acronyms in this talk, I'm sorry, but these names are really, really long. So UDHR is one that I will come back to. This was created in the aftermath of the Second World War, and it was proclaimed by the United Nations General Assembly in 1948. And it set out for the first time the human rights that should be protected. The UDHR has 30 articles, and these cover things like, this is just a selection, no discrimination, no slavery, torture, and inhuman treatment, the right to be treated fairly by the court, and the right to trial, the right to privacy, the right to asylum, freedom of thought, religion, opinion, and expression, the right to work, rest, and holiday, the right of social service, and the right to education. So you can see from these examples just how far-reaching and ranging human rights are. They cover a wide variety of things, and everybody will relate to them in different ways. All UN member states, that's countries for the most part, sign up to the UDHR, and they agree that human rights must be universal, meaning they belong to everyone, inalienable, so they cannot be taken away from someone, and indivisible and interdependent, which means that governments can't pick and choose which rights they're going to uphold. Now, having human rights is one thing, being able to enforce them is another. The UDHR is a declaration, it's not a treaty with its own legal force. For people to be able to act on their rights, countries have to have legislation that brings those rights into their own laws. This provides a legal framework for bringing cases if your rights aren't being met or are being violated. Without legislation, there's no way to enforce your rights. So when countries ratify rights, they create the internal framework to uphold your rights. Ratifying means that a country's put things in place so that the act is legally enforceable rather than just an agreement or a statement. The main legislation for human rights in the UK is the Human Rights Act of 1998, and in Scotland we also have the UNCRC Incorporation Act from last year. The Declaration of Human Rights isn't the only document on human rights, though. There are others set out by the UN that provide more specific protections for certain groups. The most important for us today in this talk are the Convention on the Rights of Persons with Disabilities and the United Nations Convention on the Rights of the Child. So we'll start with the Convention on the Rights of Disabled People, and it came into being in 2006. There are other UN rights documents around disability that predate it, but we're not going to have a history lesson here. We'll just acknowledge they existed and we'll move on. The aim of this convention was to ensure disabled people have full equality. The convention was a major step in global disability rights, from viewing people with disabilities as objects of charity or medical treatment or social protection towards trying to view them as full and equal members of society with human rights. And as the convention says, its goal was to protect and ensure full and equal human rights and freedoms for people with disabilities and promote respect for their inherent dignity. 160 countries signed up to it within a year, and 126 ratified it within 5 years. The UK has signed and ratified the convention. The US has signed it but not ratified it. There are 8 guiding principles of the convention, and I'm going to run through them. Then I promise I'll stop reading things at you. So, respect for dignity, autonomy, including the freedom to make one's own choices, and independence. Non-discrimination, full and effective participation and inclusion in society. Respect for difference and acceptance of disabled people as part of human diversity and humanity. Equality of opportunity, accessibility, equality between men and women, and respect for the evolving capacities of children with disabilities and the right of children with disabilities to preserve their identities. So the preamble to the convention, which is basically the introduction, is actually really beautiful writing if you ever want some nice bedtime reading. It talks about why this convention has been made, and some of the points that it makes includes disability results from the interaction between people with impairments and barriers, both physical and attitudinal, that limit their participation in society. It's important for disabled people to have autonomy, independence, and freedom to make their own choices and to be actively involved in decision-making. Disabled people face barriers and violations of their human rights in all parts of the world. Disabled people are diverse, and people with disabilities might have other characteristics that bring further challenges as well. The majority of people with disabilities live in conditions of poverty. And finally, it mentions the importance of accessibility in physical, social, economic, and cultural places, in health and education, and in information and communication, so that disabled people can fully enjoy human rights and fundamental freedoms. This last one is expanded on in Article 9 of the Convention, and it says that people with disabilities should be able to live independently and participate fully in all aspects of life, and they should have access to the physical environment, to transportation, to information and communications technology, and to other facilities and services that are open to everyone. So accessibility in the Convention covers 3 main things. And access to communication and information is one we're going to focus on, as well as access to physical areas and services. Won't touch on that too much today. Now, I said a minute ago that we can't enforce rights without domestic legislation. Unfortunately, with accessibility, we do have legislation that covers some of these areas, like the Equality Act in the UK. But I've also said that this talk will challenge you to think beyond accessibility and compliance, and that's what I want to do. Legislation gives us a big stick, but can we use a human rights-based approach to put accessibility at the heart of our designs? And this brings me to the kind of fundamental point of today. To access our rights, we need to understand our rights. And to understand our rights, we need accessible information. Now, this is something that I got interested in years ago. Before I was a content designer, I worked for the Equalities and Human Rights Committee at the Scottish Parliament. And there I worked on two bills, the Female Genital Mutilation, or FGM, Protection Order Scotland Bill, and the Children Equal Protection from Assault Scotland Bill, which was better known in the media as the smacking ban. This is a picture of me clerking a parliamentary committee meeting on the Equal Protection Bill, and I've got a very serious grumpy face on. Now, the FGM bill was about providing protection orders for people at risk of FGM. And this meant working on the bill, meant working with people who often had regular and recent experience of their human rights being ignored or violated. The Equal Protection or smacking ban bill was about getting rid of a legal defense that allowed parents and guardians to use physical punishment on children, called reasonable chastisement. And the bill's aim was to entitle children to the same protection from assault as adults have. Both of these bills meant that as a parliamentary committee, we needed to engage with people who maybe don't usually engage with Parliament and politicians. And this had a number of challenges. For the FGM bill, we were talking about groups where English is generally an additional language. Many were asylum seekers. They had a large distrust of government and of official structures and organizations. They didn't generally have access to desktop computers. They were avid mobile phone users. And FGM as a subject was not something that they tended to talk about. Now, I don't know if you've ever seen a parliamentary call for views. They're not exactly easy to read. They tend to have a lot of technical language. They often require a typed Word document response, and you have to address certain set questions. So it became clear, as I got to know more about the women affected in the UK, this was not going to work. It was inaccessible to them on many levels. I initially thought we could translate the consultation into the languages that were usually spoken by these women, but I met with a charity that supported them, and they said, don't bother, there's no point, because the literacy rates among these groups are so low that they would struggle to read in any language. So they told me that they preferred videos that they could watch on their phones. So we designed a consultation where the women could safely submit their views through videos and something called digital storytelling, which let them tell their experiences anonymously, but still in their own words. So this respected their rights to privacy, to safety, but also to participate in politics and decisions that affected them. Now, it meant we had to do things differently, and we had to take a different view towards accessibility and inclusion. But it set me up really well for the Equal Protection Bill. So the Equal Protection Bill was introduced in 2019, and there are proposed amendments to similar legislation currently going through Westminster that would give children the same protection in England. Now, we knew from existing research that the children who are most likely to be smacked are under the age of 12 and most commonly under the age of 8. So how do you design something that children can read and understand? That's one problem. But there's another problem. Children under 12 couldn't consent under GDPR to having their views published as part of the consultation. So that meant their parent or their guardian had to consent for them. And often, that means the person giving them permission to share their views about physical punishment is also the same person who could potentially be administering physical punishment. Now, this seemed like a bit of a puzzle, but when you're designing for children, and by that I mean anyone under the age of 18, you have an extra big stick, and there's a comma in there, it's not an extra big stick, It's an additional big stick, as well as the Human Rights Declaration. So children have additional rights set out in the UN Convention on the Rights of the Child, the UNCRC. And this has been signed by 196 countries, and it outlines the fundamental rights of every child. It's the most widely ratified human rights treaty in the world. All UN member states, except the US, have ratified the convention, and it came into force in the UK in 1992. The UNCRC has 54 sections or articles, and they cover all aspects of children's life. And they include, for our purposes, 3. Article 12, children have the right to give their opinion and for adults to listen and take it seriously. Article 13, children have the right to find out things and to share what they think with others. And Article 17, children have the right to get information in lots of ways as long as it's safe. Children should be able to access information they can understand on TV, radio, in books, newspapers, and on the internet. Professor Laura Lundy is a professor of children's rights at Queen's University Belfast and a professor of law at University College Cork. And her research specializes in children's education rights and the rights to participate in decision-making, as well as the implementation of children's rights around the world. And she's developed a model to help explain how you can enforce a child's right to participate, and it's called the Lundy model. And she says, children have a right to seek and receive information, including about their human rights. If this right is to be implemented in practice, the information that they receive needs to be available in ways that they can understand. And I love this LinkedIn post from her from a few weeks ago, where she says, children don't deserve their human rights. They don't deserve to be heard. It's not earned or lost as a reward or punishment. It's an entitlement like all human rights. So at this point in my career, I'm working on these bills. I'm not a content designer by name, but my work on these bills made me realize the importance of clear communication. If someone can't understand something, how can they participate? How can they engage in a consultation if they can't access the technology, or if the documents or the questions don't make sense? What if they need someone else to consent to contribute, or someone to translate for them? Now, the Equal Protection Bill impacted on private family life, which is a human right, but children also have rights for safety and to participate in the decisions that affect them. So again, how do we support those rights? Well, we made a special consultation for children. So we made toolkits to use in classrooms to run sessions that were facilitated by a trusted adult. And that adult could then collate the responses anonymously and send them in to the committee. We used clear language to explain what the law meant and what the changes would be. And then we fed all of that back so that they could be active participants in trying to form the views on that bill. So this was a solution, but I'm not sure it was perfect because it still relied on an adult collecting and potentially filtering children's responses. And that idea of needing someone else so that you can access your rights goes against both accessibility and a human rights-based approach. So here's a little illustration of what I mean. A couple of years ago, I did an event on making law accessible to young people. There were a lot of lawyers there, including Laura Lundy, which was quite intimidating. And I was talking about the importance of language in helping young people understand their rights. And so I decided to do a little bit of research with young people aged 7 to 17. And I showed them some content about things that they were entitled to as young people living in Scotland. One was about free bus travel for under 25s, and the other was about free university tuition in Scotland. Sounding pretty good in Scotland. I asked the children to read the information and then to tell me what it meant. Now, the language was really technical and complicated. I've got an example up here on the screen. Parents, guardians must apply on their behalf. Children under 5 already travel for free on commercial bus services. So just kind of big words, long sentences. So I asked the children to read it, and they all said they understood it. When I asked them to explain it back to me, they could give me a general idea. They would say, well, it's about university or it's about buses. But when I asked them what they would do next if they were given this information, the younger ones just said, I'll give it to my parent and I'll get them to deal with it. So this was information written about children's rights, but it wasn't written for children. And that meant that children needed somebody else to understand and access the information and their rights. The children that I spoke to all came from comfortable families where there were adults who could help, but that isn't the case with every child. And a child whose parents had English as an additional language or who couldn't access the internet would be completely prevented from accessing their rights because of how this information was presented. And children have a right to privacy too. So they might be comfortable asking their parents to explain their rights to free bus travel. But what about other areas where they might not feel the same? So, for example, would a teenager be comfortable asking an adult to explain the laws around sharing intimate images with a partner? Probably not, maybe not. So they might go looking for that answer and that information themselves. And if they did, they might find information like this, technical legislation that they can't understand. I've got an image here from the Protection of Children Act 1978 that refers to taking and distributing indecent photographs of children. It's very technical, it's very complex, but it's the information that they might need to know. So they get this, they can't understand it, then they turn elsewhere for information, to Reddit, to Snapchat, to forums that I've never even heard of. If we make information that people can't access or understand, we force them to go elsewhere and we have no control over where that is. Now, this is just one angle around accessibility, and it relates to that understandability principle of WCAG. But there are countless other ways that inaccessible information can prevent someone from accessing what they need. We've heard some of them today: images without alt text, videos without captions, animations that don't have an alternative for someone with a visual impairment. They're just some of the ways that we might be preventing someone from realizing their rights. So let's put all this together. Children are a really good example to start with because for the most part, they rely on other people to realize their rights. And the people, systems, and organizations that hold responsibility are called duty bearers. As designers, our organizations can be seen as having a duty too. And we can use what's called a human rights-based approach to think about our responsibilities as duty bearers. A human rights-based approach is a framework that puts human rights at the center of policy and design. It's meant to empower people whose rights are most at risk so they can participate in decisions that affect them. It has 5 key principles, and you can remember them with a handy mnemonic of panel. So they are participation. Everyone is entitled to participate in decision-making processes that affect them and their rights. Accountability. Duty bearers are accountable if they fail in their obligations towards rights holders. Non-discrimination and equality. All individuals are entitled to their rights without discrimination of any kind. Empowerment. Everyone is entitled to claim and exercise their rights, and they need to understand their rights and participate in the development of policies that affect them and their lives. And finally, legality. So approaches should be in line with legal and international human rights laws. Domestic and international. Some of these concepts or these ideas are probably already familiar to you in your work if you're a designer, but they are all things we need to consider. And this framework is usually used for policy and for legislation. But let's just look at what these principles might mean from a design perspective. So participation. Are we creating designs that people can use? Can they participate in the decisions that affect them? Are we being inclusive and accessible with our user research and our testing? Are we making sure we're considering a range of access requirements if we invite people to co-design something? Do we make it easy for people to participate? We don't require them to log in or to give us extra information that we don't actually need. We think back to the FGM bill. We could have created an accessible HTML page where the consultation questions were in the correct screen size, or font size, and all the color contrasts were good. It would meet accessibility requirements. But if someone can't understand the questions or access the technology to fill in a response, or if they need to speak to someone else to do it for them, is it accessible? Are they able to participate? So for accountability, what duties do we have to our users? We might be official duty bearers if we work for government or other organizations that have power, but if not, how are we responsible for the care and safety of the people using our design? Do we provide ways for people to feedback or to appeal decisions, and are these meaningful? Are we keeping our users safe? So, for example, if you're creating a space online for people to share views and experiences, is that moderated? If not, how do we make sure people aren't being compromised online? And if it is moderated, how robust, fair, and free from bias are our guidelines? And how can someone appeal, object, or understand our decision-making? Non-discrimination and equality is probably the one, as content designers anyway, that we would deal with most. Are our designs accessible? Are they inclusive? Are we considering a range of groups and users? Are we bringing any biases to our design? Remembering the intersectional and diverse experiences of people, how broadly have we considered the users of our designs? Empowerment, and this is my favorite. Do our designs support people to act independently, to get and understand information, and to participate in things that affect them? Are they accessible to a range of users? Are we disempowering anyone through jargon, through confusing content, through user journeys that don't make sense? I recently tried to complete an online consultation. The webpage crashed 3 times. It didn't recognize my address format. It asked confusing but mandatory questions that I had to answer to move on. I gave up after 3 tries. So I tried to participate in the process. I got nowhere. It was disempowering because of inaccessibility and bad technical builds. So finally, legality. Are we considering things like data protection, accessibility legislation, and other rights when we design? And are we aiming for mere compliance with those laws, or are we designing to the spirit as well as the letter of the law? Now, a human rights-based approach is also really useful when we come across what seem to be conflicting rights or priorities. And this is something you might see in design work when you talk about competing user needs. What do you do when one person's or group's rights appear to be at odds with another's? So let's go back to the smacking bill. Children were at the heart of the bill, but so were parents. And one of the rights in UDHR is about private family life. Article 8 protects your right to respect your right to respect for private family life. And private life means the right to live without the government interfering. But children also have the right to be safe. Article 19 in the UNCRC says, I have the right to be protected from being hurt or badly treated. Governments should make sure that children are properly cared for. There should be laws to protect children from violence, abuse, and neglect from adults. So in cases of conflicting rights, a human rights-based approach gives us a clear answer. We are to prioritize the group whose rights are most at risk. So in this case, it's the children. And if we think about this for a minute, it might turn things completely on the head for us as designers. If we're used to taking a top tasks approach where we're designing for the most common need, what does this mean? What does it mean when we talk to stakeholders about accessibility and the situations that we bring up or the users we're talking about are dismissed as edge cases? If we can actually embed this approach, if we can put it into the heart of our design work, what might that look like? Would we maybe prioritize creating BSL content for a web page? And not only that, but put it at the top of the page, which is where BSL users generally look for it, because we're prioritizing their access to information. Would we have the backing to build accessibility in first and not last? It's exciting. So we've talked a little bit about people whose rights are at risk, but usually when I mention human rights and content design, people's minds go straight to things like information in war zones, or terror attacks, or other major crisis situations. So we're going to talk about that for a bit, because what I've talked about so far might seem a bit theoretical, but for people whose rights are at risk, this isn't theoretical. And there are a few different things to think about here. So I'm going to split them into the technical bits and the emotional bits. So first off, technical constraints. Somebody who's trying to access critical information in a crisis might be dealing with low battery and low signal. They might not have a reliable power source to charge their device. They might be in a location with poor network connectivity. And depending on the situation, they might not be able to move to fix either of those things. So we have to design in a way that's lightweight, that functions with low bandwidth. And in many crisis zones, governments can control information. They can cut off internet access, messaging tools, or access to certain news sources. So we have to think about how information can be distributed and how it can be received when standard channels are blocked. We also need to think about the emotional constraints. When people are actively, currently experiencing trauma or a crisis, they're not operating in a normal cognitive state. Stress hormones lower cognitive function, and you can't think as well as you normally can. Asking someone to make a decision, to weigh up options, or to decipher what they need to do next is asking a lot. So, what do we do when we design for a person in this state? Well, we want to focus on clarity, using clear and direct language, simple processes. Don't overwhelm with choices, give clear instructions. And we want to prioritize accessibility. Video content with subtitles and transcripts, again, remembering to design for low battery and low signal. Now, hopefully the good news is that a lot of this is stuff you're doing already, and we're not really doing anything differently. We're just applying our skills to situations where they're most needed. I've got this far without a technical problem, come on. There we go. Okay, so if we bring all these things together, accessibility, human rights, crisis situations, what does that look for us as designers? So imagine a government needs to send out an emergency alert, and we've all got recent experience of this from Sunday. I forgot, it made me spill my cup of tea. I've got a couple of examples on the screen here. One is from a UK government alert used last year and using the alert system to let people know about a red wind warning. And the other is a slightly older text message about COVID lockdown rules. We might have views about the language used here. I do, but these are just a couple of examples. Now, the design of these kinds of messages can have life or death consequences. A poorly designed message might be something like a text-only alert that is too long or uses technical jargon. An accessible message is going to consider technology, battery life, signal. It's going to think about the effect of stress and trauma and what that might be doing to someone's cognition. And it might include, for example, formats for visually impaired people or people with low or no literacy. Because the point of this is people need to know information and how to act on it. My colleague Miriam Viswani does some great work on this, on crisis communications, and I've got a resource at the end that I can point you to if you want to know a bit more. So those are the accessibility considerations. A human rights-based approach would also consider balancing rights and needs. So for example, the right to safety and security under UDHR Article 3, with what the government might need people to do. For example, do they need people to leave their homes and their belongings in order to stay safe? And it would also consider which groups' rights are most at risk and how they can be prioritized. And we need to make sure that our message provides factual, non-biased information so people can make informed decisions about their safety. So you can see there's some crossover between accessibility and human rights thinking. For example, if we thought that the people whose rights were most at risk in this scenario were people with visual impairments or low literacy, how would we change our design for them? Would we prioritize a video message instead of text, or would we think about using other channels? And what if the crisis situation was in response to a political protest rather than a weather warning? So the government wants to disperse crowds or direct them away from an area. And we might have two conflicting needs again. The protesters' right to freedom of peaceful assembly under UDHR Article 20, or the public's right to safety and security under Article 3. And this is assuming a benevolent government that is allowing the protest and simply concerned about people's safety. When the messages are being controlled by a different kind of government, what difference does that make? And something that we need to mention here is the role of tech and communications companies in human rights violations. And Amnesty International has just released a report called Breaking Up with Big Tech, which looks at the power of the big 5 tech companies to perpetuate human rights violations. And they write, when a small number of companies control the primary gateways to information, their decisions can have systemic effects on the public's ability to access diverse viewpoints and thus on access to information, freedom of opinion, and expression. This means that as designers working in these spaces, our choices have ethical implications. To prepare for this talk, I put a message out on LinkedIn. Some of you might have participated, thank you. And I asked people for a one-word answer. What is the first thing they think of when they see human rights? And I got a lot of answers, and I've made them into this word cloud. And the most common response was dignity, followed by freedom, justice, safety, and respect. And these are all good words. But if you look closely, if you can see, there are others. Injustice, erosion, oppressed, unequal, Gaza, misappropriated, fail. It's clear that human rights for many people are not a shiny beacon of hope. 77 years on from the Declaration of Human Rights, we're looking at rights today in a digital context that its creators could never have dreamed of. But we can apply the spirit and the ambition to our design work. We can use the idea of human rights to promote dignity and equity. It doesn't need to just be a big stick in our list of things that we can wave at stakeholders. A human rights-based approach gives us the framework and the authority to argue that an edge case for the business is a fundamental right for the user. Eleanor Roosevelt, one of the main campaigners behind the Declaration of Human Rights, famously said, "Where, after all, do universal human rights begin? In small places close to home. Unless these rights have meaning there, they have little meaning anywhere." We can bring those rights into small digital spaces, and we can help our users begin to access their rights. A few resources for you if you want to grab a picture, if you want to know more. Professor Laura Lundy, who works on the children's rights model, she's got a lot of things out there about helping children participate, explaining rights to children. Errol Fox is an amazing service designer. They've got experience in design, technology, and human rights, and they write and share a lot of resources about designing in areas where human rights are at risk, so in those kind of crisis zones and situations. I mentioned my colleague Miriam. She's written a chapter called Crisis Communication, A Crisis is More Than a Moment in Time, in the book Designed with Care, Creating Trauma-Informed Content. I have to declare an interest in that, but a lot of the chapters are available for free online. You do not have to buy the book. And she's also got all her resources that she used in the chapter for free online. So if you're interested in knowing more about crisis communications, that's a really good place to start. And Emily Albon is a director of legal design at City Law School, and she's launched a website and resource called TLDR. And this showcases different ways of making law more accessible to all. And that's it. Thank you very much.
Thanks, Rachel. That was really interesting. There was loads to take away. I made loads of notes frantically. But something you touched on and didn't go too much into was about how you can use these when you're building communities and kind of the codes of conduct within that space. And so often they are a list of things that you should adhere to. And I just wondered if you had either experiences or guidance for people who are looking to build those themselves around how to ensure that this is considered as part of building those communities, and if you had any advice on how to enforce them or kind of maintain them within that space.
So you mean the panel principles themselves?
Yeah, I think that, or anything else that you've got from takeaways or experience, because it's something that I'm looking at the moment.
Yeah,
really relevant.
The panel principles, you're in luck because they are designed for that sort of thing. That's where they come from. It's about working with communities and supporting people in that sort of developing a service or developing a policy situation. So there's lots out there. Scottish Human Rights Commission have some really good resources as well. What I've tried to do is take those into a more digital context where it's maybe less about working directly with people, but I think the important bits to remember are when you're involving people in things like co-creation or user testing, user research, and how accessible, how much you're supporting people to participate, because it's all well and good saying we're going to have a consultation on this, but if you put it in an upstairs room in a community centre that doesn't have bus transport and there's no lift, you're not actually supporting people to be able to participate and co-create with you. So, but yeah, Scottish Human Rights Commission, most of my work on human rights comes from the Scottish context, so I'm a bit biased, but they've got some good things.
Did you have a question, Craig? Yeah.
Thanks. I was curious in terms of the impact these have kind of day to day or in your work. Do you see that secondary stick having an impact, or because I'm just thinking there's a lot of, I suppose, very obvious examples of human rights being violated, and there's a lot of stuff where people are reversing some of the rights and those sorts of things. So I'm just wondering, in terms of the stick, how useful is it?
Yeah, it depends. I think you probably found the same talking about accessibility. You've got some people who you mention WCAG and they're like, oh, we must comply, we must do this. And you've got other people who are like, yeah, but I think human rights is another way of approaching that argument. Most people don't know that you have a right to information you can understand. So if you say to stakeholders, as a content designer, I'm looking at something and it's full of jargon and it's really technical, and they're like, yeah, but it's fine. And you say, well, actually, it's going against someone's human rights. It might give them that moment of going, it might not. It's another tool that we can have. I think what excites me is if we bought into this in the same way that we approached things like with the top tasks approach, where instead of designing for the many, we're designing for the people who are most vulnerable. I just think if we can do that, and I know our power as designers is often limited, controlled by other people, but if we can start thinking that way, I think it's really exciting.
Thanks.
Is there any more questions for Rachel? Oh?
Hi, sort of similar to that last vein, I think a lot of the things you mentioned in the Equality Act, for example, sort of hinges on that word reasonable, and it's often used sort of as a way to get out of things. Are there any sort of support with talking to people who will just turn around with that sort of, it isn't reasonable for the company to do X or Y, and it's sort of, it's something that I've seen a lot across physical, digital spaces. It's just almost a cop-out. So any tips there?
Yeah, so that kind of idea that we don't have to make this website accessible because it'd be unreasonable, too much work to do it. I think, as far as I know, I'm not a human rights lawyer, that caveat does not apply to human rights. There is no, we only have to make a reasonable effort to make information relevant to you or that you can understand. It's not in there, it's quite clear. So I suppose in that sense it's a stronger kind of protection, it's a stronger mandate. As Craig was saying though, you've still got to get people to buy into it. But the good thing about having that equality legislation is you do have maybe the theoretical, but at least it's there, the mechanisms to uphold those human rights.
Thank you.
Pass it on. Well, this will be the last question.
Kind
kind of following on from that in terms of having the mechanisms, and you talked about having the legislative sticks for things.
Yeah.
You also mentioned that this is kind of assuming a benevolent government. What if you don't have a benevolent government? What does that mean that at that point, how critical is that? Like, is it possible to still be incorporating human rights into design if, for example, you're in a country that, has revoked its legislation on the Human Rights Declaration?
Yeah, so benevolent governments, that point I was kind of just making around the messaging, but it is a wider point and it's a good one. And I guess what I would say is it is about having those legal frameworks in place, making sure that they can't be eroded, which we are of course seeing, and then also having the mechanisms to enforce them through the courts as well, if you need to. So all of that, you're right, it will very much depend on the countries, the situations that you're in. I'm not saying that human rights gives you a magic wand, to keep with my stick analogy. It is another tool, it's another way of thinking about things. For some people, it sounds powerful and important. Hopefully we can return to a space where for all of us it's powerful and important and upheld. But you're absolutely right, there are places where, if you're going and saying, well, we need to think about blind users as a priority in this website, you're not maybe going to get that attention that you should have. I don't know if that helps at all. I'm agreeing with you, I think.
Thank you very much. Thanks, Rachel. Thank you.